Hello, my name is Stuart White, and I've graduated from both medical school and law school. Now I'd like to pass on some of my knowledge to future students as well as people who have general interest in either medicine or the law. These videos are for educational purposes only, so if you have specific questions, please consult a professional. This video is an overview of torts in general. A tort is a civil wrong as opposed to a criminal wrong. Civil wrongs are usually something where someone has done something to somebody else or someone else's property, as opposed to a criminal wrong, which is something that's against the law, or in other words, is a crime. Typically, a civil wrong is between two people where one person commits an act or fails to act, which then results in harm to another person or another person's property. This is opposed to a criminal wrong where someone does something that's against the law. In a tort, which is a civil wrong, typically the plaintiff is the person who was wronged and the defendant is the person who caused the harm. A criminal wrong is where someone commits a crime or does something against the law, and typically the plaintiff is the state or the government or the people enforcing the law, and the defendant is the person who committed the crime. Torts are usually divided into intentional torts, negligence, and strict liability. There are also several miscellaneous torts. Generally, the more someone is to blame for the tort, the more liable they are. Typically, there are not punitive damages unless the person acted willfully, wantonly, or maliciously. When presented with a fact pattern that may contain a tort, you want to identify each potential tort, look at the specific fact patterns, and then decide if a tort occurred. You then want to look and see if there's a possible defense for the tort. You then look at what damages are possible from the tort. These damages include actual physical damage or loss of use, but they also include non-specific damages. But they also include loss of use and loss of value, loss of companionship, emotional distress in some cases, medical costs, both immediate and future medical costs, as well as possible future loss of income. Sometimes you can also have punitive damages. When deciding whether a tort has been committed, you want to look at intent. Intent means that somebody acted or failed to act with the specific desire to have something happen for a specific result, or they knew with substantial certainty that the result would occur. One of the classic examples is somebody pulling the chair out from behind someone else. Even if they're not 100% sure the person's going to fall, it's pretty certain that it will. It can't just be probably or maybe or likely. It has to be substantial certainty. Intent can also be transferred to someone else. You may intend to shoot person A, but they duck out of the way and you accidentally shoot person B. Even if this happens, you are still liable for committing a tort against person B, even though they were not your intended victim. Remember, the intent is the act that you commit, and the result may happen to someone else or something else. After you've established intent, you want to look at defenses to the torts. One of the main defenses for a tort is consent. Consent can be either express, such as a contract, or implied. People have to have capacity to provide consent. This means someone who's drunk, someone who's mentally disabled or injured, or someone who's a minor may not be legally allowed to give consent. After intentional torts, we have negligence. Negligence typically involves duty, breach, causation, and harm. The defendant has to owe a duty to the plaintiff. They have to then breach that duty. That breach of the duty that they owed them must actually cause the harm that occurs. It's important to look at the conduct at the time that the harm occurs. You always want to take into consideration what is reasonable. You look at what a reasonably prudent person would do under the circumstances. This includes their physical condition, but does not include their mental condition. So in other words, someone who's blind would be treated as what a reasonable blind person might do in that circumstance, versus someone who may have a psychiatric or mental disorder. This would not be taken into account when considering their duty or their intent. Children are typically not held to an adult standard unless they're performing a typical adult activity, such as driving a car, operating a chainsaw, things like that. It's also important to look at what the local custom is. The local custom can provide some context, but is not definitive, but it may give you some idea of what a reasonable person would do in that situation. Negligence per se is another type of negligence. This is where the negligence is actually spelled out in a law. When you look at negligence per se, you have to look at the particular type of person the law was designed to protect, or the particular class of people. In negligence per se, you have to look at the typical type of person that the law was designed to protect, or the class of people the law was designed to protect, and you have to look at the specific harm that the law was designed to prevent. If those are not both established, then there may not be a negligence per se. When you look at duty and breach, you need to identify whether the defendant had an actual duty to either act or not act in that given circumstance. And then you have to look at whether it was reasonable. Breach means they failed to act or failed to not act. Typically, people do not have a duty to help someone else unless there's a special relationship. These include parent to child, husband and wife, innkeeper and tenant, etc. When looking at duty and breach, you also want to look at whether someone assumed the risk of the activity. Assumption of the risk can either be express or implied. Expressed assumption of the risk is when you sign a contract before you get on a roller coaster or other dangerous activity. Implied is when you voluntarily do something that you should know may be dangerous. When looking to see if someone's liable, you want to look at whether or not they have some type of immunity. This can be government immunity, parental immunity, etc. There's vicarious liability. This would be someone who is liable even though they didn't actually commit the act or omit or fail to act. The typical type of vicarious liability is when an employer is liable for an employee's actions. This is called respondeat superior. The final type of tort is strict liability. Strict liability includes abnormally dangerous activities and product liability. Abnormally dangerous activities include things like blasting with dynamite, transporting hazardous chemicals, etc. Product liability includes defects, which cause harm to someone, or warranty defects. Keep in mind that the harm has to be actual harm. Plain emotional, simply emotional harm is typically not enough. The harm has to be actual physical harm or loss of value or loss of use. Attorney's fees are also typically not covered unless that's specifically in a contract or the tort was particularly egregious. Also remember, there will not be punitive damages unless the defendant acted willfully, wantonly, or maliciously. The next video will go into more detail about intentional torts. Negligence. Future videos will discuss negligence and strict liability in more detail. Please remember that these videos are for educational purpose only or for entertainment And if you have any specific medical or legal questions, you should seek professional advice and should not rely on these videos